So I'll go through this, which is very basic, but it'll give you the idea of what you need to know, and you can ask me questions at any time, okay? So I think it's on page 33 in your handouts. So over here, this is the crime investigation and prosecution like flowchart. Actually, there should be another step up here, which is the crime is committed, okay? And now that the crime's committed, it could be that it's never reported to the police. Or it could be that the victim reports it, a neighbor reports it, a witness reports it, someone else reports the crime to the police. The police go to the scene of the crime, the locus, and they begin investigating. What's involved in a police investigation? Keep quiet, Grant. What will the police do? They'll take a statement from, firstly, the victim, if they're there, and if they're able to give a statement. And I think the victim's statement might give a picture around where, what happened. And then other pieces from witnesses around, any witnesses that are there. What else?
Collect any evidence.
Collect any evidence, so maybe physical evidence, clothing, other things, DNA evidence, the forensics that are involved, CCTV footage, any other type of evidence that might be helpful for that investigation. Anything else? Maybe appealing to the public we talked about yesterday to come forward for information if someone was there at that date and time. Door-to-door inquiries were mentioned yesterday. Various different things. They'll pursue different lines of inquiry. Their purpose is to try and identify a suspect, actually rather than accuse, identify a suspect and then eventually build a case against that suspect for there to be enough corroborative evidence to charge the suspect to make them an accused. Make sense? Mm-hmm. Okay. And then they can bring that person, that suspect, in for questioning. And how long can the police hold someone for questioning? Do you know? 24 hours?
Does it depend on what
You can bring someone in for questioning for up to 12 hours, from my understanding. And after those 12 hours, you either need to release them, charge them, or with authorization from a senior officer, and there needs to be grounds for it, extend it for another 12 hours. So up to 24. But I think it's different in something like terrorist charges. You can do it 72 hours or something else. But roughly that's the time frame. After that, you need to decide whether to charge someone, release them. And if you charge them, it could be that you charge them, but then still release them on police bail with an undertaking. I don't know if it's an S-22 undertaking or something like that, for them to attend court at a later date. Or they could be remanded in custody, kept in custody. And that's what it's saying here, really. However, if the police attend a scene of a crime, they might use their discretion and take no further action. Okay? They don't have to bring someone in for questioning. They might go to a scene, maybe there was a disturbance at a house, property, or something like that, a party, let's say. They used their discretion. They didn't think any further action was required. Nothing was done. Okay? Or they could issue an on-the-spot warning or fine. And that could be more in road traffic offences, etc. So let's say I caught Grant driving with his mobile phone. I would issue him a fine, an on-the-spot fine, or a warning, or something else. The route that we're more concerned with here is where the police are able to build a case against that suspect and charge that suspect, and they send a report to the Procurator Fiscal, which is what we said was cleared up or solved in number 2, remember? Are we okay with that so far? You with me? Okay. So that report that they send to the Procurator Fiscal would probably contain, at the time of the investigation, any of the evidence that they have, statements and other things that they may have on that case. It doesn't mean it's ended there, because once the Procurator Fiscal receives that, and maybe the person is taken into court for their first appearance, the Procurator Fiscal still might ask the police to carry on with their investigations. Does that make sense? It doesn't necessarily, the police are done and the Procurator Fiscal's taken over. That's not how it necessarily works. The person is maybe brought into court for their first appearance, and then, again, they would be making a plea or not, or they would be making a decision on keeping them in custody or releasing them on bail. and this would be court bail then. And anyone could be released on bail, even murder suspects. Okay? There needs to be good reason to keep someone in custody, remand them in custody. And the reasons might be around if there are potential risk for victim, for other witnesses, whether they might commit further offences, whether they might abscond or escape or leave the country, whether there's a risk of them not attending further dates or committing further offences, etc., etc. Or if they did release someone on bail, they might put special conditions based on someone's release. They need to reside at a certain address. They need to be there at a certain time, etc., etc. Those are special bail conditions. So that would happen here at the first appearance, and that happens in a sheriff court. So you might read, if you follow BBC News and other news channels, and you look and you read about when a crime is committed and stuff, it'll say there, that person will appear at the sheriff court in the next working day, or something like that. If it's a Friday, it might be the Monday, or something, Tuesday, whatever. Are we okay so far? Mm-hmm. Now, at this stage, the Procurator Fiscal needs to decide, what am I going to do with this case? Am I going to make an offer of one of these direct measures? So what in Stephanie's case, remember I said to you, maybe pay for the car tires to be fixed and then leave Michael alone. Or maybe the Procurator Fiscal said to you, Stephanie, either you would pay for the car tires to be fixed, and pay £150 to Michael for this and this and this, and we want you to go to anger management class, and we'll avoid taking you to court. Do you accept that offer or not? And you can either accept it or not. If you say no, then they might prosecute you in a court. Or they might drop the case. Hopefully not. But they will prosecute you if it's in the public interest. And all decisions that they take will be in the public interest. That was in the video. And the public interest has a range of different things that's taken into account. To give you an idea on some of the things, they look at the nature and the seriousness of the crime, the impact of prosecution on victim, on witness, the age and personal circumstances of the victims and the witnesses, the age, background, and personal circumstances of the accused, how long ago the event took place, are there any mitigating circumstances, the effects of prosecution on the accused, the victim, the local community, what the general public opinion might be, the risk of further offending, are there other remedies that are available before going down the route of prosecution. So there could be here in your case, for example, we talked about a fixed penalty order, so maybe that's a fine, on-the-spot fine. A fiscal fine, you pay money to the state or to the public. A compensation order, money directly to the victim. A diversion from prosecution, anger management, drugs, etc. Or a work order, a community sentence. It could be a mix between all of them. Does it make sense? Mm-hmm. It is an admission, I think, of guilt if you accept the offer in some respect. However, there is another route, and that's no prosecution. So after weighing everything up, as it said in the video, they may decide no prosecution. And that's a really difficult decision to make. And to give you an idea, like I know you mentioned about the road traffic for you, but the bin lorry case in Glasgow, where you had a bin lorry, guy lost control for various reasons, 6 people died, another 14 people were injured, no prosecution. Really hard for the victims' families to stomach that and take that. But whether there's maybe not enough corroborative evidence, there's no charge, no evidence of a crime or an offence was committed, or it's generally not in the public interest after weighing all the factors up, they may decide on a no pro, you might hear it as, or no prosecution. The one we're more concerned with, if we keep going, is prosecuting someone. And then it's the Crown Office and Procurator Fiscal who need to decide what court to prosecute someone in and what is the charge. What does the evidence say in terms of a charge? Does that make sense so far? You with me? Mm-hmm. Any questions before I move to the next slide? Okay. So here then the Procurator Fiscal decides, should this be a summary procedure or should it be a solemn procedure? And what we said on a solemn procedure is more serious with a jury. And a summary procedure is no jury. And in a summary procedure, you can have a justice of the peace court or a sheriff court. Okay? So for road traffic offences, breach of the peace, and as I said, what they deem more minor offence, not necessarily you, but what the evidence says here and what the Crown suggests is a more minor offence would be in a JP court, Justice of the Peace, or in a sheriff court with no jury, because these different courts have different sentencing powers. All, for example, rape cases or murder trials must be in a high court because they carry maximum of life sentences. I've got another slide to show you. But here we can have a sheriff court that has a jury and a sheriff court that does not have a jury, a JP court that does not have a jury, and a high court that always has a jury. Make sense so far? Ultimately, in each of the courts, eventually you'll have a verdict if you have a trial running. And in terms of verdicts, you have three. You have not guilty or not proven, where the person will be released, and you have a guilty verdict. Okay, so I'll ask you one or two questions. So, how many jury members would you have in Scotland?
12.
That's England.
8.
15 in Scotland. 15 members of a jury in Scotland. So let's just say you have 5 jurors who say guilty, 5 jurors who say not guilty, and 5 jurors who say not proven. That's 10 against 5 in favor of an acquittal. So someone will be released. You need at least 8 jurors to say guilty, to have guilty by majority. If all say guilty, that's unanimous. Thank you. Unanimous verdict. So, not proven, we said yesterday, a bit of stigma left on both sides, but ultimately, in reality, it means the same thing as an acquittal. It means a release. Guilty verdict here, it depends on the court whether directly after the verdict there may be the sentence straight away. And it's more likely here, where you have the verdict happens and then the sentence happens straight after, because it's the same person who decides the verdict and the sentence here. Although when you have a jury, juries decide the verdict, and then the sheriff or judge sets the sentence. And there could be a break, there could be a gap. And you might, if you've read news reports and things like that, you may have heard the sentence is deferred. You ever heard that term? So it's delayed. It could be 3 weeks, it could be 4 weeks. And that's a point where the judge or sheriff might instruct social work reports or background reports or inquiry reports to be conducted. And that might bring in whether someone had a history of offending, their circumstances and various things. You have maybe a criminal justice social worker who will produce those reports. And at the same time, the defense might give arguments about mitigating factors to try and bring the sentence down. And then you would have the sentence, and then it doesn't necessarily end there. There could be an appeals process later. However, someone might get to this and they plead guilty, in which case you don't go through a trial, you just go straight to sentence. And if they plead guilty early, there's a discount that's often given on their sentence. And the sheriff or judge will usually highlight what that discount is. It could be 15% or more.
At any time throughout that, can they change their plea?
Yes.
Right.
At any point in the trial, you can change your plea.
The last one there.
Yeah.
Right, okay.
You can change it to guilty.
Uh-huh.
You know, if you
And
plead
you
not
can't go
guilty
back,
in the beginning, and then you plead guilty, you can't change it.
Yeah.
You know, once. Yeah. But that would be kind of the court would stop agreement between parties, and then they'll come in and say they wish to make a plea or something like that. And if you have more than one accused on a trial, I have seen that happen, that the Crown Office have offered, for example, a lower charge, which they've pled guilty to, and then it's something that they call turn Crown. So that witness then becomes a Crown witness, a witness for the prosecution to help against that person. So that's risky. Okay, do we understand that so far? Good. Okay, let's move on to the next slide. And I think you will find it in your handouts on 34. And here it's giving you an idea of the different types of courts. So we said we've got a JP court, and in the JP court we've got no jury. The justice of the peace decides on the verdict, and it's the same justice of the peace that sets the sentence. Maximum £2,500 fine, and up to 60 days in prison or custody. Those are the maximum levels. The £450 fine at a maximum of 2,500 in JP court. A sheriff summary. Again, we've got a sheriff. And what is a sheriff? It's not like you're a cowboy in America. What is a sheriff?
Does he act as a judge?
A sheriff is a type of judge, right? And a sheriff actually has been involved in the law for at least 10 years. Has 10 years experience as either a prosecutor, a defense solicitor, etc. And then they have been nominated by the First Minister and appointed by the Queen to be a sheriff. Okay? And then they are a type of judge. The same goes with a high court judge. Okay, that's the term given for a high court judge, is a judge. And they have at least 15 years experience in the law and nominated by the First Minister, appointed by the Queen. But from my understanding, it's not an automatic progression from a sheriff to a judge. It's not just, oh, if I've got 15 years now, I'll become a judge. It's not like that. Here we have no jury in a summary. Sheriff decides verdict. Sheriff sets sentence. Maximum £10,000 fine and up to 1 year in custody or prison. So that's why this might happen much quicker. Verdict and sentence straight after each other because it's the same person, verdict and sentence. But when we look at solemn procedures, we have a sheriff and we have the jury. And the jury decides the verdict. The sheriff or the judge in the High Court will give what they call the judge's charge or direct the jury. Say to the jury, there is enough evidence here or there's not enough, or give them parameters to look at. But ultimately, the jury decide amongst themselves. Anyone ever been a jury member? Yeah? What court was it? Sheriff. So you were Sheriff Solomon. What was the charge? Do you remember?
Two brothers that were causing mayhem in a park, but they were throwing bottles and injured last potential.
Okay, so maybe a serious assault or something like that. Okay. And did you get to the point of deciding verdict? Yes. How was your deliberations?
It was everybody agreed.
Everyone agreed.
Yeah.
Okay, so relatively straightforward then. And the sheriff then would set the sentence. After the jury decides the verdict, I think you would be dismissed and thank you for your time. Your job is done. And then the sheriff decides what the sentence will be. And in terms of a sentence, it's an unlimited fine or up to 5 years maximum in prison. Okay? And then we'll go to the High Court. We've got a judge and a jury. And then the jury decides the verdict again, the judge sets the sentence, and it's unlimited fines, and it's up to life in prison. Okay? The highest level of the criminal court. Does it make sense so far? Okay. You need to know each one because actually you might be involved in any of these courts. Even if your court that you are volunteering in, let's say it's Witness Service Livingston, and Livingston is a sheriff court, you might have summary trials there. You might have solemn trials for the sheriff court. Some JP courts are integrated within a sheriff court building. So, for example, Glasgow, they've got JP courts inside the Glasgow Sheriff Court building. However, for example, like Livingston, well, let me ask you this first. How many high courts do we have in Scotland? Let me rephrase. How many buildings in Scotland say High Court? 3. Glasgow, Edinburgh High Court, and Aberdeen High Court. However, you're saying, oh, there's Perth and this and that. That's because Livingston is a sheriff court building. But if there's a judge sitting on that case, and judges travel around the country on circuit, that becomes a high court trial, regardless of whether it's a sheriff court building or not. You've got a judge sitting on the case, it's a high court trial. So you might hear the phrase something like, the High Court is coming to Livingston, the High Court in Perth, the High Court in Ayr, the High Court in Paisley. Those are Sheriff Court buildings, but the trial is a High Court trial, because you have a judge sitting on it, and then it carries those maximums. Make sense? So you need to know the different terminology that comes with all Sheriff and High Court trials. Okay, and I'll show you that. It's in your handouts, this. About who's who in the court, I think on page 37, 38, and 39, although just listen to me, okay? I'll tell you who's who. Here we have a sheriff or judge, and as we said, they're the person in charge, sitting on the bench. This, anyone recognize him? No. Okay, that's Lord Brackadale. So you can see in a high court, they wear this kind of robe with the wigs. In a sheriff court, it's usually black with the wigs. Okay? And they sit highest up. They decide on legal arguments. They set the sentence. They make sure that witnesses, victim, accused are all treated fairly and given fair trials, etc. Okay? The person responsible for the case, for the trial. You've got the sheriff clerk, clerk, as you want. I don't know how you pronounce it, or the clerk of the court, or the clerk to the court. If the sheriff or judge is sitting up here, the clerk will be just below them. Okay, and that person's role is keeping the administration of the court going. So they have all the documents of all the papers for all the witnesses, all the charges. They make amendments to the charges. They make announcements in the court. They keep the diary of the sheriff or judge to set a new date and various other things. You'll see them in the video I have for you. A very important person, and probably second in charge when the sheriff is not there, in a way. Then you've got the procurator fiscal, the advocate. We said that's a person prosecuting the case, presenting the case against the person accused of the crime on behalf of the state, on the public. And the title given in the High Court is an advocate, or fiscal in the sheriff court. Here we have the defense counsel, so the defense solicitor. They are representing the person accused of the crime. And they will challenge all the evidence. They will test the evidence. They also get to ask all the witnesses questions, and they may have their own witnesses they want to present in the case. We have juries, and we said 15 members of the jury chosen at random from members of the public. There we have witnesses in the witness box. So we've got prosecution, defense, and professional witnesses. And you'll see someone sitting just behind me there. That person is a very important person. That is a court officer. Okay? So the court officer is the title in a sheriff court or a macer in the high court. Now that court officer here is the person who will put things in front of me, like the evidence. We call them productions. Exhibit A, B, that's America. In Scotland, we use the word production. Okay? So they would put a statement in front of me, or a photograph, or something else for me to look at. And that person is the one who would have left the court, gone to the witness room, found me, and escorted me back. So that's why I say it's a very important person for us, because our witness service would communicate with the court officer who would be in the building, who would be giving updates to witnesses, etc. They also escort the sheriff or judge in and out. They ask the people to stand when the sheriff or judge is leaving. And the title given in the high court is a macer. Any idea why it would be a macer? So you'll see in a high court, if you've ever been to a high court, they carry a mace. And they put it up on the back of the court to show when the court's in session or when it's not in session. And I think it's a more historical thing, because we're talking way back here, where the mace was used to protect the person who was going to collect the fines, as you know, from the criminals. It's just ornamental now. You have police and security in the court. Obviously police to maintain order. And what you'll find is that they may be located somewhere in the corridor of the court, but also inside a courtroom, especially in solemn trials, in a high court trial as well. And you'll see they're pretty standard in the court, in particular courts. There's space for the public to attend, and also there may be designated places in certain courts for the media. Okay?